Good afternoon to everyone. In particular, a very good afternoon to Associate Professor Falin Jayatissa and the faculty of the university here. We are indeed very grateful to the Singapore University of Social Sciences and in particular the School of Law for hosting us. And I'm also gratified with a turnout of an audience that I think encompasses quite a large subsection or cross-section of the legal community in Singapore. And I really do hope that you will find the discussion we have this afternoon relevant for your work and for the continued development of the legal profession in Singapore. I should also note the presence of my colleague, Judge of the Appellate Division, Kanan Ramesh, and also to my former colleague, the Deputy Attorney General, Mr. Ang Ching Hock, who have spared the time to join us this afternoon. Now, the title of my speech this afternoon is Technology as a Bridge to Justice. Now, the courts here have embraced technology to not only support lawyers, but also empower members of the public in navigating legal processes. And what we aim to do is by leveraging technology is to enhance accessibility, transparency, and efficiency within the legal system. However, one of the themes of my message this afternoon is that amidst our digital advancements, we must remain mindful of the segment of the public that lacks access to technology, and it is crucial as we progress towards a more technologically driven legal landscape that we do not leave anyone behind. At the first installment of the Conversations with the Community, our Chief Justice shared, for example, how the Family Justice Court's divorce and probate e-services can be used to generate court papers that are needed to apply for a divorce or for a grant of probate in certain cases. And it's also shared that we've been exploring the use of generative artificial intelligence to advance our mission of access to justice. And I'll be touching briefly on these aspects in my sharing today. The primary objective of innovation and adoption of technology in the judiciary in Singapore is to serve the public better by ensuring greater efficiency through faster and cheaper services and lower manpower costs. And within the specific context of the judiciary and the legal system as a whole, additional aims would include the elimination or reduction of errors, the facilitation of the work of judges and lawyers, and improving access to justice. Strengthening fairness is also to be achieved by harnessing technology to help judges achieve just outcomes by facilitating the work of scrutiny of arguments and evidence. On the flip side, however, we must ensure that we don't pursue innovation simply for innovation's sake. As a public agency, the judiciary has a responsibility to ensure that public money is spent prudently, and experimentation and risk-taking, while to be encouraged, any effort must be geared towards a better and more efficient administration of justice with the aim of serving the needs of the public. So let me first expand on these topics by explaining how the courts see our role in the justice system. The courts exist not just to resolve disputes, otherwise we're no different from arbitration or mediation chambers or other forms of dispute resolution that have been common throughout the world. The primary function of the courts is to further justice according to law. And the Constitution, after all, confers upon the superior courts the exercise of judicial power, and the junior courts are subject to its supervision. To fulfill that function, the courts cannot be merely passive and reactive to changes. The courts have a systemic role in furthering justice. And this means that the court should take the lead in identifying improvements to processes, capabilities, and facilities in the justice system. That would include the proper harnessing of technology. Now, this interplay between technology and justice may bring to mind images of robot judges and other tropes of science fiction. Some of these may yet come to pass, but in determining what technology should do for justice, it is essential first and foremost to consider what justice entails. And in that analysis, it is evident that what parties may seek from the administration of justice will vary along a spectrum. At one end, there are those who have the ability to obtain sophisticated legal representation through lawyers who are more than able to handle complex procedural applications, complex factual disputes, and hearings that may take a substantial amount of time. At the other end of the spectrum are those who may not be able to afford legal representation or who choose, for one reason or another, not to, and who may have difficulties coming to grips with and navigating the legal system. The cost of legal representation has indeed been increasing, and there is a greater readiness on the part of many to make do without lawyers. And increasingly, many types of proceedings are done without lawyers as a default. The causes of these are varied. There is a great desire for simpler, faster procedures, saving time and resources. And there's been expansion of tribunal proceedings in Singapore as an example of this. And all along that spectrum, there'll be varying requirements and demands. The needs of small or medium enterprises may differ from multinational corporations or from individuals with family offices. Other areas outside civil disputes, such as criminal law and family law, may also throw up other challenges which I may not be able to examine fully in today's speech. But the justice system needs to look at the various forms of needs and work out measures to facilitate justice for each category of party. In this effort, technology needs to be leveraged to overcome obstacles and address shortcomings, and in respect of complex commercial matters, the role of technology is primarily geared towards efficiency. This is not a trivial exercise. Such efforts can be geared towards a range of activities, and it is incumbent upon the courts to make sure that it has the appropriate systems and facilities in place to make hearings as smooth as possible. So this would include allowing lawyers to bring in and use their preferred litigation support or case presentation systems wherever possible, to ensure that we have the facilities for quality of life improvement in litigation, such as automatic simultaneous transcription and translation, facilitating remote hearings wherever desired, such as by allowing seamless remote testimony and presentation of evidence, and also putting in systems to assist judges to make sense of voluminous evidence, including documents, and to more easily reach decisions and produce judgments. In comparison, facilitating justice for the person in the street will encompass a few different aspects. Primarily, it will be about enabling that person to participate in and pursue or defend proceedings in court. So this will require the person to understand the processes and requirements of the law, being able to participate fully by complying with procedures and processes, being able to present their case and being able to marshal, gather and present evidence, and to make legal address and arguments on the law and on the facts, as well as to understand the outcomes and consequences, including any form of enforcement, as well as the right to appeal. So the law is particularly a difficult area to facilitate engagement. We have a lot of specialized learning and expertise requiring years of training as provided in various universities, including SUSS, with specialist vocabulary, special modes of behavior, and all of this means that the law is often quite alien to the experience and expertise of the person in the street. So technology promises the possibility of meeting those needs. But technology alone cannot be the solution. It has to be tied in with a change in approach in culture and philosophy. Institutionally, the courts, including its judges, judicial officers, and administrators, would have traditionally seen the courts as a disinterested organization. We would have seen ourselves as neutral and passive. So parties would bring disputes to us, have it determined by the courts, and the judges and judicial officers will not take an interest in the outcome or participate in any way. But such passivity is no longer enough. The courts do have, as identified by the Chief Justice in his inaugural opening address in the Conversation series, a systemic role. So there is a balance to be struck in fulfilling that systemic role between the necessary neutrality to ensure fairness in our processes and providing assistance. So what does this mean? Essentially, the court should not cross into providing a party so much assistance that it crosses into advocating for that party, or that its actions show bias or preference for one party over another. Some have argued from this that the court should also not provide any form of advice as opposed to information. But the line between advice and information is thin, and to my mind sometimes illusory, and is something that we should move away from. The essential point is that courts have an active role in assisting parties in what they do, and technology should be utilized to play in this effort. Technology is not a panacea or the sole instrument, and must be part of a holistic approach that encompasses relooking, re-engineering of processes, reform of substantive laws, and organizational or cultural change. And all of these aspects must be relooked from time to time. And there must be a constant commitment to share or to cut away whatever is unnecessary. There will always be things that accrete to the process that get tacked on, and we must always be on our guard to make sure that there are no unnecessary additions to the process that basically jam up mechanisms and processes which are intended to achieve justice for everyone. So it is true that in all that we do, there will be various risks. Sometimes it is about information security. Digital information is often more readily accessible and copied than other forms of information. Sometimes it is about improper behavior, such as perhaps parties or lawyers or even judicial officers making improper use of generative AI, for example. And other risks may also be posed, for example, the risk or danger of leaving behind groups of people, such as the vulnerable or ill-equipped, for example, by leaving out those who cannot use computers or phones to access court services. Such risks do exist, but the solution is not to shy away from what needs to be done to develop and innovate, but to work out appropriate mechanisms and safeguards. So let me turn now to some of our initiatives that flow from this basic approach. The current objectives of our present state of development technology are twofold. Firstly, we want to promote and facilitate Singapore's continued growth as a dispute resolution hub and center for legal work within the region and beyond. But secondly, as I've mentioned, it is to ensure continued and better access to justice. So directions have been given by the Chief Justice in various speeches. Firstly, on an annual basis in his opening of legal year speeches. Secondly, on other occasions, such as his speech on technology and exchanging face of justice, delivered in 2019. And thirdly, in his opening address in the Conversations to the Community series in September last year. The central points are that technology is an important bridge or enabler for access to justice, and the courts must promote such access in fulfillment of our systemic role as the institution charged with responsibility for the administration of justice. The courts must ensure the fair and efficient administration of justice, and in fulfillment of that, must help develop systems and processes that deliver and excel in such administration. And this includes assisting court users in understanding and navigating the justice system, what we refer to as our assistive responsibility. So our approach is aligned along the following categories. Firstly, access to justice. Secondly, promoting efficiency. And thirdly, harnessing data. And these form the three large categories in our reformed Courts of the Future framework. Let me take first access to justice. So technology facilitates access to justice by allowing self-represented persons who were previously referred to as litigants in person or pro se litigants, basically people without lawyers, to navigate the legal system on their own without the need to engage lawyers or advocates. This is a necessary function of the legal system. And to serve the public, the end users, the legal system must work towards facilitating such access. And everyone must come together to remove obstacles. And this requires questioning of the rules and processes currently in place. So what this means in essence is that there must be constant exploration of what systems might assist the self-represented person. A big need on their part is how they deal or confront or engage with the legal system. So laws are hard. They are often written in technical and specific language that's not clear for the average person. Relevant laws may be spread over different resources, not just in one place. It will be very difficult for a layperson who's not trained to find out what matters without doing research. And even then, even if they manage to carry out the relevant research, there might still be mistakes, or they might be confronted with confusing statements of the law. The self-represented person needs help to understand the legal issues, and we would need to explore how different solutions, such as using generative AI, guided forms, and perhaps simpler and more user-friendly presentation of information will help such persons. At the same time, the courts will have to confront the issue of what can be legitimately done. So as I mentioned, there is a tension in many common law jurisdictions between providing information and straying into the provision of legal advice, which the courts cannot do. So this has led in the past to an extreme reluctance to help the SRP in dealing with court processes. And all that was done in the past was to direct the self-represented person to the nearest legal clinic or to the Law Society of Singapore to get their own legal advice or to find a lawyer. So basically the courts will say, please go somewhere else, get help from someone else. But this is no longer sufficient. The courts have an obligation to assist the self-represented person, at least in the provision of legal information, so that that person can consider what steps can be taken in his or her own interest. But yet another aspect of access to justice, an important one, is to divert parties away from contentious legal processes wherever possible, so that they are assisted to achieve appropriate outcomes, perhaps through mediation, so that they can avoid the costs and pain of litigation if they should choose. In this regard, outcome simulators such as the Motor Accident Claims Online system, which I will touch on, are an important outlet for such efforts. Let me turn next to efficiency. So efficiency efforts reap the primary objective of the adoption of technology, which is greater productivity, by making work easier, faster, and more accurate than before. So in respect of lawyers, this would cover, of course, e-filing, case management, and document management. Now, some of these activities would fall outside the purview of the courts, such as document or matter management within the law firm. But the courts would have a stake and interest in facilitating presentation of cases in hearings. Ideally, to minimize friction and reduce transaction costs, there should be free and unimpeded flow of information from the law firm systems into the court system, and vice versa, subject, of course, to proper security gatekeeping. Lawyers would also be helped by easier and faster legal research and anything that promotes faster and efficient writing. And as indicated by the discussion on access to justice, efficiency should also encompass easier filing and conduct of cases by self-represented persons wherever possible. Turning next to data. So harnessing data is an important function of technology. Data properly used and exploited allows us to gain intelligence about trends that are beneath the surface, obtain evidence about possible causes of problems, and allows us to perform granular and detailed analysis of issues. All of these can then assist in better judicial administration to allow the courts to refine judicial policy and anticipate and prepare for increases or decreases in caseload, for us to identify new trends which may require more expenditures, more resources, more training and education of judges, and for us to check on the effectiveness of legal doctrine. Of course, harnessing data alone will not be enough. There will have to be concurrent efforts to have better interpretation and better empirical research skills. In addition, data will also be useful for the government, allowing agencies to, for instance, to gauge the demographics of criminal offenders or for those seeking divorce early in a marriage. And this will allow the government as a whole to have better calibration for intervention by way of new policies and statutes. Let me turn now to some specific project examples. So I've mentioned earlier our Motor Accident Claims Online system. This is an application to allow users to see what is the likely determination of liability if they were to pursue an accident claim in court, and also the quantum that's likely to be awarded. So the user is able to input various parameters, such as the type of road junction and the position of the vehicles involved, in order to get a prediction of the likely determination of liability. So in accident cases in Singapore, the courts will generally determine the proportion of liability between two parties, such as 50, 50, 30, 70, and the like. The liability indicator will be able to give this estimate, allowing the user to consider whether it would be worthwhile to pursue the claim, and perhaps importantly, motivate the user to settle if an offer is made that is close to the estimate. The quantum simulator then helps the user to identify the likely award for the various kinds of injuries that may be suffered in an accident, such as fractures and whiplash, and this will also hopefully assist in the settlement of cases. These systems were developed by the judiciary and are currently hosted by the Academy of Law. The authentic court order system enables a user to determine that a copy of a court order is in fact authentic and issued by the Singapore courts. Previously, such authentication would require a stamp and a signature of a duly appointed officer indicating that the copy is indeed a certified true copy. Getting such a physical certified true copy of any document can be cumbersome. The user or the member of the public has to physically come down to the courts to arrange for certification. Instead, with our ACO system, a unique QR code is displayed on our court orders, allowing the bank or any other institution to whom the copy is sent, to quickly check online whether what he or she sees is indeed what was issued by the courts. We had, in implementing this system, preferred this form of technology other than other emerging systems, including blockchain technology. We aim to choose a system that served its needs without being overly complicated. In family proceedings, we have worked on the development of simplified tract divorces, which allows a self-represented person in simple divorces, that is, where parties agree on the reasons for divorce and the orders to be made. We've allowed the self-represented person to prepare and file documents easily online with accompanying guidance and the automatic generation of the required court papers. We have also rolled out a document signing service, allowing documents to be signed digitally on e-litigation by making use of our national digital identity system, SingPass. Documents on e-litigation may be signed by linking up the relevant document to the SingPass authentication system. And in addition to digital signing, we have made use of another aspect of the SingPass system, allowing letters and notices to be sent to an inbox on that app. Leveraging on that capability, we have since September 2022 also made it possible to perform substituted service of documents through the SingPass app inbox, and such applications may also be expanded in the near future. The SG Courts mobile app for e-litigation was developed to allow those on the move to access e-litigation documents, and also in response to lawyers being not just digital native, but also mobile native. Currently, this app allows lawyers to access their case files, view documents and hearing dates, and also obtain queue numbers for their hearings. We are continuing to explore other functionalities. Asynchronous hearings are hearings in which the parties of the courts are not actually together at the same time. In several situations, court hearings need not involve all of them and the judge being brought together. And in particular, many administrative hearings can be conducted asynchronously without everyone being together at the same time, either physically or remotely. So asynchronous hearings using emails were instituted in the pandemic, but this was a bit cumbersome, and to facilitate tracking and ease of use by parties and lawyers, a new asynchronous hearing system on e-litigation was launched, with the discussion being kept on record within the case file. And we hope to extend this functionality to SG Courts mobile app before too long. Another area that's important for judges is the transcript of evidence given in court. Machine recognition of spoken testimony is challenging, and a 90% rate of accuracy still introduces too many errors, which are distracting and may affect the accuracy and reliability of transcript. So work is ongoing for us to develop a transcription system that is accurate with as low an error rate as possible. We face a number of challenges in this area, including accent, the language used, and the quality of recording, including challenges from microphone placement. But we are hopeful that we will be able to overcome these challenges in the future and facilitate parties obtaining a transcript or record of proceedings, and to hopefully reduce the cost of obtaining transcripts from the courts. Let me turn next to generative AI. Now, we all know about the recent burst of innovation sparked by the introduction of generative AI, and we've not been spared in the justice system. So let me briefly outline our efforts in this area. The Singapore Judiciary signed a Memorandum of Understanding with Harvey AI in August 2023. Harvey AI is an American startup developing legal AI, having obtained backing from OpenAI, who are the people behind ChatGPT. It has already entered into partnerships with one of the largest law firms in the world, Allen & Overy, as well as PwC Legal, among others. The MOU we've entered into is aimed at promoting access to justice. Our objective here is to use AI to assist self-represented persons in navigating legal processes, and we want to start off first with small value claims in the Small Claims Tribunal. So we are looking at using AI to assist self-represented persons, firstly, in filing their claims, in understanding what evidence they need to produce, help them to present their cases, and give an estimate of the chances of success, and perhaps nudge them towards settlement if possible. In addition, we also hope to have the AI assist the judges, the Small Claims Tribunal magistrates, in examining the evidence that are presented to them. In many cases, the volume of evidence and submissions in these cases can be fairly voluminous, even though the parties are not represented by lawyers. As the self-represented persons are not legally trained and are varying educational levels, the materials they rely on may be a mixture of the relevant and irrelevant. So going through the evidence, trying to separate out what is relevant, what is not, sifting basically the wheat from the chaff, is a laborious and time-consuming process. So we're exploring using Harvey AI to help our tribunal magistrates summarize and digest these materials. But alongside our collaboration with Harvey AI, we are also testing out other generative AI models, including some developed by the government agencies in Singapore. So this is basically part of our exploration of this space. The Singapore Academy of Law, which runs the LawNet legal research system, is also exploring the use of generative AI to assist our legal research capabilities. So we are also particularly keen on examining AI use in both transcription and translation. So my colleague, Mr. Tan Ken Hui, will I think, be presenting on some aspects of this very shortly and demonstrate some of our other products that we are testing. So all of these efforts together will lay the foundation for the further use of AI in the courtroom in other contexts. We are also aware that the use of generative AI, whether by the courts, lawyers, or the self-represented persons, throw up a number of important issues, including ethics, security, and the confrontation of the digital divide. We are developing guidance documents to be issued publicly to remind users, both lawyers and self-represented persons, of what they should be aware of and what they should disclose to the court and other parties when they use generative AI. Legal practice will certainly face substantial challenges, and generative AI tools may assist self-represented persons to do without lawyers in more litigation contexts. Corporate clients may also feel that they can easily draft contracts and agreements without involving lawyers. And traditional business models will be disrupted by the increasing availability of generative AI tools in various areas of work, usually undertaken by junior, younger, and unfortunately cheaper lawyers, including document review, legal research, and aspects of discovery. So this in particular highlights the challenges for legal education and training, which will require adaptation and change, both in law schools and in the early years of legal practice. So I should mention that a judicial governmental committee is taking these concerns on board and is looking at reforming legal education and continuing development. So let me conclude then by highlighting again that the impetus for innovation comes from across the legal sector, with multiple centers of development. Many law firms and individual lawyers are aware of the need for constant innovation, and thus increasingly we see many law firms experimenting with new technology, business models, and paving and pioneering the way. Many individuals in the legal sector and outside have chosen to pursue careers in legal technology and legal services. And this is to be welcome, as an increased variety of drivers will help ensure flexibility, and is testament to a deep acceptance and comfort with technology and innovation in Singapore, and will help ensure that the Singapore legal sector remains ready for the future. But nonetheless, even with widespread innovation, the courts must continue to lead the way in its systemic role as the institution tasked under the Constitution with the determination of disputes, and its wider role in ensuring the proper administration of justice within Singapore. We, of course, work in tandem with our partners, and this is exemplified by the close cooperation we have with all stakeholders in the legal sector, such as the Attorney General Chambers, the Law Society, and the various ministries, including the Ministry of Law and the Ministry of Finance. Much assistance and support has been obtained from the main government technology agencies as well, including GovTech. And we, of course, also work very closely with the 3 law schools in Singapore. What I hope to convey to you today is that the Singapore court's journey of digitalization and adoption of technology continues. We do not pretend to have all the answers right now, and we have made our own share of errors, and as in any other area of innovation, there will often be uncertainty, insecurity, and sometimes fear. The management of cultural change will also require shifts in perceptions, beliefs, and practices. But what is unchanging are the basic values underlying our institution and all of those of us who serve in it. For those of us in the courts or in legal practice, the essential value is of upholding fairness and justice with the aim of better achieving justice according to law. So whatever challenges there may be in further technological innovation, in launching large programs, or in dealing with day-to-day frustration, the courts will continue to work with our partners, stakeholders, and social welfare organizations to ensure that we leave no person behind. Thank you.